वेलकम फ्रेंड्स फॉर यूपीएससी लेबर एनफोर्समेंट ऑफिसर एग्जाम जो कि 2023 में अर्ली 2023 में होने का जिसका चांस है। उसके लिए व्हाट विल डू, जो लास्ट पेपर हुआ था वो कब हुआ था 2017 में। सो 2017 वाले पेपर का विल डू द डिटेल्ड सॉल्यूशन क्वेश्चन बाय क्वेश्चन। जितने 120 सवाल आए थे एक एक करके हम लोग सारे करेंगे। सो गाइज किसी भी एग्जाम के लिए, किसी भी कॉम्पिटिटिव एग्जाम या कैसे भी एग्जाम के लिए सबसे पहला स्टेप होता है कि हम पुराना पेपर देखें और पुराने पेपर से हम लोग सीखने की कोशिश करें, वट एवर वी कैन लर्न फ्रॉम दैट पेपर। सो दैट इज द ऑब्जेक्टिव ऑफ डूइंग प्रीवियस ईयर पेपर। तो एक एक करके पूरा पेपर हम लोग सोल्व करेंगे, ठीक है। बट बिफोर डूइंग दैट, बिफोर स्टार्टिंग विद क्वेश्चन नंबर 1, आई वांट टू शेयर विद यू 5 थिंग्स, ठीक है। एक एक करके शुरू करते हैं। सबसे पहली बात, ऑफ कोर्स पुराने वाले पेपर सबसे पहले हम क्या सीखने की कोशिश करते हैं कि कौन सा सेक्शन ज्यादा इंपॉर्टेंट है, किससे ज्यादा सवाल आए, किससे कम आए, किस पे ज्यादा फोकस है। ये हम सबसे पहले हम ये चीज देखने की कोशिश करते हैं। सो गाइज इससे पहले पेपर 2017 में हुआ और उससे पहले 2015 में हुआ। 2015 में एलईओ के लिए नहीं हुआ लेकिन एएलसी के लिए हुआ। 17 में एएलसी प्लस एलईओ दोनों हुआ, करेक्ट। सो पेपर इज सेम, एलईओ और एएलसी का बिल्कुल सेम पेपर होता है। इट्स नॉट इवन सिमिलर, इट इज सेम, ठीक है। तो अब 15 और 17 को अगर हम देखें, सो जो 2015 का पेपर था उसमें लेबर लॉ से अप्रोक्सीमेटली 45 सवाल आए। ऑन द अदर हैंड जो 2017 में पेपर जब हुआ तो लेबर लॉ से अप्रोक्सीमेटली 60 क्वेश्चंस आए। सो जंप ऑफ 15 क्वेश्चंस। ऑन द अदर हैंड अगर आप इंडियन पॉलिटी देखो तो इंडियन पॉलिटी के अप्रोक्सीमेटली 25 सवाल आए 15 में, जो कि कम होके 2017 में सिर्फ 10 सवाल रह गए। सो माइनस 15 क्वेश्चंस। तो इससे हम क्या, व्हाट कैन वी लर्न फ्रॉम दिस। सो पहली चीज जो हमें इससे सीखना है वो ये है कि इससे कुछ भी नहीं सीखना है। यूपीएससी के रिक्रूटमेंट एग्जाम्स में द वेटेज ऑफ टॉपिक विल कीप ऑन वेरिंग, और ये होता आया है। और ये सिर्फ हम एलईओ या एएलसी के लिए नहीं बोल रहे हैं, बाकी जितने भी रिक्रूटमेंट एग्जाम्स हैं उन सब में भी आगे पीछे वेटेज हमेशा होता रहता है। तुम खुद से जैसे ईपीएफओ का पेपर देख सकते हो, पहले 17 में हुआ, फिर 22, फिर 21 में हुआ। इसमें भी जो वेटेज ऑफ टॉपिक्स है, इसमें लेबर लॉ के 20 सवाल आए, फिर अगली बार 10 हुए। सो वेटेज ऑफ टॉपिक्स विल कीप ऑन वेरिंग। हो सकता है अब जब तुम लोग अपना पेपर लिखोगे 2023 में, तो एचआरओबी जिससे 10 सवाल और 8 सवाल आए हैं, तुम्हारे में इससे 25 सवाल आ जाए, ये भी हो सकता है। सो पहली बात जो सीखने की है कि इससे कुछ नहीं सीखना है और सारे टॉपिक्स को इक्वल इंपॉर्टेंस, इक्वल रिस्पेक्ट देना है, पूरा सिलेबस हमें पूरा करना है। यह है बात नंबर 1। लेट्स कम टू सेकंड थिंग, कट ऑफ की बात करते हैं, ठीक है। सो जो 2017 में जो एलईओ का पेपर हुआ था उसमें कट ऑफ आज अप्रोक्सीमेटली 160 मार्क्स आउट ऑफ 300। इसका मतलब क्या है, हर एक सवाल 2.5 नंबर का था, तो जिसके 120 में से जिसके 65 के करीब मार्क्स थे, दैट पर्सन गॉट कॉल फॉर इंटरव्यू। ये कट ऑफ था 2017 में। तो इस कैन वी कंक्लूड कि अब की बार भी इतना ही कट ऑफ होगा? अगेन नो, इससे भी कुछ नहीं सीखना है। यूपीएससी के रिक्रूटमेंट एग्जाम्स में कट ऑफ में देयर इज सिग्निफिकेंट वेरिएशन, एंड आई कैन गिव यू वन एग्जांपल जिससे यू विल अप्रिशिएट दिस पॉइंट। जो ईपीएफओ का एग्जाम हुआ था, पहले एक बार 2017 में हुआ, फिर वो 2021 में हुआ। जो 2017 में ईपीएफओ का पेपर हुआ उसमें जिसके 120 में से 58 सवाल ठीक थे, नेगेटिव मार्किंग को हटा के, उसको इंटरव्यू का कॉल आया। जब यही पेपर 2021 में हुआ उसमें जिसके 120 में से 78 to 80, एग्जैक्ट नंबर अभी आना बाकी है बट वी नो इट, ठीक है, 120 में से 78 to 80 सवाल जिसके ठीक थे, उसको इंटरव्यू का कॉल आया है। सो जंप इन कट ऑफ कितना? 20 क्वेश्चंस, 20 मार्क्स नहीं, 20 क्वेश्चंस, माइंड इट। तो गाइज इससे क्या समझ में आता है कि कट ऑफ को लेके प्री कंसीव्ड नोशन के साथ एग्जाम में नहीं जाना है। हो सकता है कि तुम्हारा पेपर आसान आ जाए तो कट ऑफ 120 में से 80 से ऊपर चला जाए। हो सकता है पेपर मुश्किल आए, कट ऑफ 120 में से 55 सवाल पे ही जाए, 1/3 काफी ज्यादा नेगेटिव मार्किंग होता है, तुम्हारे सारे एफर्ट को पानी में बहा देगी। प्रेशर में नहीं रहना है कि मुझे इतने नंबर लेने ही लेने हैं, इतना कट ऑफ तो पे जाना ही जाना है, जस्ट डू योर बेस्ट। तीसरी चीज पे आते हैं, अब हम पेपर करने वाले हैं, उससे पहले 5 बातें मुझे आपको बतानी है। तीसरी क्या है? टाइम मैनेजमेंट। इस वाले पेपर में टाइम मैनेजमेंट का ज्यादा वैल्यू नहीं है। क्यों नहीं है? 120 सवाल आएंगे, 120 में से 10, 15 या 20 इतने सवाल होंगे न्यूमेरिकल एप्टीट्यूड के, बाकी सारा पेपर थ्योरेटिकल है। सो मोर देन 100 क्वेश्चंस आर थ्योरेटिकल। थ्योरेटिकल का मतलब क्या है कि तुम्हें 10 सेकंड में पता चल जाएगा कि तुम्हें आता है या नहीं आता है। 10 ने चलो 20 सेकंड में पता पता चल जाएगा। सो जितने भी टॉपिक है, एचआर, ओबी, वो भी तुम्हारे सिलेबस में लिखा नहीं है पर पढ़ना है वो भी, ठीक है, या लेबर लॉज, पॉलिटी, ये जितने भी टॉपिक्स हैं सारे थ्योरेटिकल है। सो अगर तुम एलईओ में फेल होते हो तो सिर्फ इस कारण फेल होगे कि आता नहीं था, लेकिन इस कारण फेल नहीं होगे कि मैं टाइम मैनेजमेंट में गड़बड़ हो गया। ऑफ कोर्स बेसिक्स तो इन प्लेस रखना ही पड़ेगा, ऐसा नहीं कर सकते कि एक सवाल पे तुमने 8 मिनट लगा दिया और फिर टाइम मैनेजमेंट तुम कह रहे हो उसका वैल्यू नहीं है। बेसिक तो इन प्लेस करना ही पड़ेगा। सो व्हाट आई एम ट्राइंग टू से, थर्ड थिंग, टाइम मैनेजमेंट के लिए इतना वरी नहीं करना है। फोर्थ थिंग गाइस, अब हम ये वाला पेपर कर रहे हैं, ये वाला पेपर कौन सा है? एलईओ का, जो कि 2017 में हुआ, ठीक है। अब एक ही पेपर है, करेक्ट, अब एक ही पेपर से हम कितना सीखेंगे? तो तुम्हारे लिए कुछ और पेपर भी हैं जो इक्वली ही रेलेवेंट हैं। तुम्हें क्या करना है, इसके अलावा जो एएलसी का 2015 का पेपर हुआ था वो भी अच्छे से करना है, ठीक है। उसके बाद जो एएलसी का 2013 में हुआ था उसको तुम रहने दे सकते हो। क्यों? क्योंकि उस टाइम थोड़ा पैटर्न, थोड़ा सब कुछ थोड़ा अलग था, 120 की बजाय 100 क्वेश्चन आते थे, वो सब था, उसको इग्नोर कर देना। पर एएलसी 2015 का पेपर भी तुम लोगों को करना है। उसके अलावा तुम्हें क्या करना है, ये वाला पेपर करने के बाद यूपीएससी के जो रिक्रूटमेंट एग्जाम्स हैं, जिसको आरटी हम लोग बोलते हैं, उसके जो पेपर हैं वो भी तुम लोगों को पिछले सालों के करने हैं। उसमें कौन कौन से पेपर आते हैं? जैसे कि ईपीएफओ, ईएसआईसी, डीडी, एडमिन ऑफिसर। अब एडमिन ऑफिसर कई उसके लिए होता है, ऑर्गेनाइजेशन के लिए, डीआरडीओ के लिए, जीएसआई के लिए, किसी और के लिए भी हो सकता है, ठीक है, बीआरओ के लिए, ये सारा करना है। फिर, और ये सब यूपीएससी की वेबसाइट पर अवेलेबल है सारे पेपर बाय द वे। उसके अलावा तुम लोगों को करना है स्टोर मैनेजर, नोट मैनेजर, स्टोर ऑफिसर। उसके अलावा सीएसडी मैनेजर। अब ये सारे पेपर भी तुम लोगों को प्रीवियस ईयर के करने हैं, क्योंकि इनका जो डिफिकल्टी लेवल है वो भी सेम एज एलईओ पेपर है, बट विद द लुकिंग एट द कीवर्ड ऑफ द सिलेबस। फॉर एग्जाम्पल, इन पेपर में, इन सारे पेपर में तुम्हें सवाल मिलेंगे जनरल इंग्लिश के, वो छोड़ देना है, इंडियन इकोनॉमी के छोड़ देना, इंडियन फ्रीडम स्ट्रगल छोड़ देना है। लेकिन इन सारे पेपर में जो एचआर के सवाल हैं, लेबर लॉज के हैं, जो ओबी के हैं, जो आईआर के हैं, जो पॉलिटी के हैं, जो न्यूमेरिकल एप्टीट्यूड के हैं, वो सारे सवाल भी करने हैं। कंप्यूटर नॉलेज है, छोड़ देना। ऑफ कोर्स सवाल देख के तुम पहचान नहीं पाओगे कि किसका कौन सा सवाल है। बाय द वे, अगर आप एनरोल्ड हो ह्यूमन पेरिटस के साथ, फिर तुम्हें कुछ नहीं करना है, ये सब हमने तुम लोगों को करके ऑनलाइन टेस्ट प्लेटफॉर्म पे हमने दे दिया है, बस तुम्हें निकालते जाना है, आगे बढ़ते जाना है, ठीक है। इसके अलावा तीसरी एक चीज और करनी है, जो यूपीएससी के रेगुलर एग्जाम्स हैं वो भी तुम्हें कुछ कुछ करने हैं। अब वो कौन कौन से करने हैं? सीआईएसएफ, सीएपीएफ, ऑफ कोर्स अपने सिलेबस के कीवर्ड को देखते हुए। उसके अलावा जो सी सेट का पेपर है गाइस, सी सेट जो सिविल सर्विसेज प्रीलिम्स के लिए होता है, उसमें जो न्यूमेरिकल एप्टीट्यूड के सवाल हैं, दे आर आल्सो इक्वली इंपॉर्टेंट। वो वाले सवाल भी, और ये मैं तुम्हें पूरी लिस्ट अभी दिखा देता हूं, वो वाले सवाल भी तुम्हारे उसमें आते हैं। अब प्रीलिम्स में एक जीएस का पेपर भी होता है, जीएस में पॉलिटी है, पर वो नहीं करना गाइस। मैं सिर्फ सिविल सर्विसेज के न्यूमेरिकल एप्टीट्यूड के सवाल मैं तुम लोगों को करने के लिए मैं तुम लोगों को बोल रहा हूं, मतलब, ठीक है। इनफैक्ट ऐसा भी होता है, और ये हम जानते हैं, हमने देखे हैं कि एक सवाल 2015 में सी सेट में आया, फिर 2019 में किसी रिक्रूटमेंट एग्जाम में आ गया, या फिर अदर वे अराउंड आल्सो किसी रिक्रूटमेंट एग्जाम का पेपर सी सेट में आ गया। हमने सी सेट का भी एक सवाल किया हुआ है, ये सब भी ऑनलाइन टेस्ट प्लेटफॉर्म पे हमने तुम लोगों को अवेलेबल करवा दिया है। सो गाइस, हम लोगों ने क्या किया कि ऑनलाइन टेस्ट प्लेटफॉर्म पे यूपीएससी के जितने भी एग्जाम्स हैं उनके सारे सवालों का हमने पेपर को पहले उसको तोड़ दिया मतलब उस पेपर में से पॉलिटी अलग कर लिया, इकोनॉमी अलग कर लिया, जनरल साइंस अलग कर लिया, जितने भी टॉपिक्स हैं, ठीक है। फिर उनको एक एक का डिटेल्ड सॉल्यूशन निकाला और वो सब हमने ऑनलाइन टेस्ट प्लेटफॉर्म पे लगा दिया है। और कोई भी किताब छूने से पहले ये सारे सवाल जरूर कर लेना, क्योंकि आपस में यहां से सवाल रिपीट होते हैं। Hey guys, so we'll start with the paper. So अगर किसी को before I start with the first question, अगर किसी को कुछ और चीजें हैं जो तुम लोगों को डाउट्स होंगे कि सिलेबस कैसे करना है, तैयारी कैसे करनी है, वेटेज ऑफ टॉपिक्स तो मैंने मोटा मोटा बता ही दिया, एग्जाम कब हो सकता है, ठीक है। तो इन सब चीजों के लिए अलग अलग वीडियो यूट्यूब पे अवेलेबल है, आप उनको जाके देख सकते हो। अगर तुम लोगों को देखना है कि ह्यूमन पेरिटस का क्या प्लान है, तो गो टू वेबसाइट ऑफ ह्यूमन पेरिटस, एक बार तुम लोगों को मैं दिखा देता हूँ। सो आप लोगों को गूगल करना है, गो टू ह्यूमन पेरिटस को सर्च करोगे आप, ठीक है, और द फर्स्ट लिंक, और यहाँ से आप लोग यू विल गो ऑन द पेज ऑफ लेबर एनफोर्समेंट ऑफिसर, इस पेज पे चले गए और इस पेज को पूरा एक बार अच्छे से पढ़ लीजिएगा। यू विल अंडरस्टैंड कि कैसे कैसे तैयारी करना है, क्या अप्रोच है, हमारा जो कंटेंट है उसका सैंपल बुकलेट का चेक कीजिए, कुछ क्लासेस भी चला के देखिए कि कैसे क्लास में पढ़ाई होता है। अगेन गाइज, अनदर थिंग, यहाँ ना कुछ इंटरव्यूज हैं, साक्षी चुग, संजीत कुमार, जो लोग सिलेक्ट हुए हैं 2017 में या ये रिक्रूटमेंट एग्जाम के, गाइज स्पेशली साक्षी चुग का, इनका इंटरव्यू जरूर देखना है। इसलिए नहीं कि हमारे बारे में अच्छी बातें बोलेंगे, इसलिए कि इनका जो प्रिपरेशन का तरीका था, जो इन लोगों ने किया, उससे भी काफी चीजें हम लोगों को समझ में आएगी, हमें कैसे आगे बढ़ना है, क्या करना है। सो गाइस, विद दैट नोट शुरू करते हैं। लेट अस स्टार्ट विद पेपर ऑफ 2017 जो कि हुआ था लेबर एनफोर्समेंट ऑफिसर के लिए और एएलसी एग्जाम के लिए। लेट्स गेट स्टार्टेड।
Okay, the first question is, consider the following commissions or committees. First, National Commission on Labour, Labour Investigation Committee, Royal Commission on Labour, National Commission for Enterprises and the Unorganized Sector. So basically, we have to arrange these commissions or committees in ascending order in terms of their submission of reports. So first, National Commission on Labour, it was set up in 1966. And it submitted its report in 1969. Labour Investigation Committee, if we talk about, that is more popularly known by Reggae Committee, right? And it was formed in 1944 and it submitted its report in 1946. Royal Commission of Labour, that was under the chairmanship of J.H. Whiteley, and it is also popularly known as Whiteley Commission. So it was formed in 1929 and it submitted its report in 1931. National Commission for Enterprises in the Unorganized Sector, that was formed in 2004 under the chairmanship of Dr. Arjun Sen Gupta, and it submitted its report in 2006. Okay, so the right chronology is C, 3, 2, 1, 4. Okay, so Royal Commission on Labour first, then Labour Investigation Committee, first National Commission on Labour, and then Commission for Enterprises in the Unorganized Sector. Next question. Family planning became an integral part of labour welfare as per the International Labour Organization resolution passed in which year? So basically this ILO resolution was passed in the year 1947. The correct answer is D. Next, which of the following are not correct approach with respect to welfare services undertaken by the organizations in the commercial and public organizations? So if we look at the question, second, third and fourth, all are correct. Only one is incorrect. So the right answer to this question is A. Okay, next question is, which one among the following is the earliest labor law in India? So these kind of chronological questions are specifically asked in this exam. So if you know the year of passing of various labor legislation, you would be able to give them a correct hit in the first go. So Contract Labor Act, if we talk about, then that was passed in the year 1970. Trade Union Act, that came in 1926, Employees Compensation Act 1923, and Factories Act, that the first Factory Act, that came in 1881. So this is also their favorite question. They do ask question, when was the first Factory Act passed? Okay, so it was 1881. So the answer is also Factories Act to this question. Next, which one of the following theories of labor welfare is also called efficiency theory? Functional theory, public relations theory, religious theory, philanthropic theory. So if we are talking about these theory, basically functional theory is the efficiency theory of labor welfare. Which of the following statements with respect to housing is or are not correct? So three statements are given. It's a basic requirement for living life with dignity. Okay, if you go by logical answering to this question, even if you do not have heard about this thing, revised integrated housing scheme 2016, so consider the first statement. It's a basic requirement for living life with dignity. Yes, this is correct statement. So the question is asking about not correct statement. It means we can overrule these two, A and C, right? So these cannot be the answer. So you need to find out answer in between B and D. Okay, so when we go through the document on revised integrated housing scheme 2016, the first line itself says that housing is a basic requirement for living life with dignity. Okay, and why was this scheme introduced? Because basically whatever poor workforce is there in India, they face difficulty in constructing house for themselves because of the various financial constraints. So this is the basic reason, and that is why the government thought of to provide them with housing subsidy. Okay, and the incorrect statement. So first statement is correct, and in the second statement it is mentioned that this scheme is for workers. Central assistance for a new house may be released in 12 equal installments. So this statement is incorrect. It is stated that it will be released in 2 equal installments. So this statement is incorrect. And the last statement, house listing and housing census data of 2011 is provided by the Office of Registrar, Journal and Census Commissioner. Okay, so this is also correct. So only second statement is incorrect. So the answer to this question is B. Okay. Next, which of the following benefits can be combined under the ESI Act 1948? So basically this is a straightforward question, and it has been mentioned in the ESI Act that which of the two benefits cannot be combined. So sickness benefit and maternity benefit, that cannot be combined. So basically it is mentioned there in the act itself. Sickness benefit and temporary disablement benefit, that cannot be combined, right? Maternity benefit and disablement benefit for temporary disablement, that cannot be combined. So which means option D is correct. Which one of the following is the total period of maternity leave admissible to a woman employee having 2 or more than 2 surviving children under the provisions of Maternity Benefit Amendment Act 2017? See, this question paper belongs to 2017, and therein they are asking you question on amendment of 2017, which was there in Maternity Benefit Act, right? So you should be aware of amendments also. Okay, so latest amendments can be asked. Okay, so total period of maternity leave that was admissible prior to this amendment, that was 12 weeks. Now this is enhanced to 26 weeks. Okay. However, the question is basically asking you that how much maternity leave is admissible to a woman employee having 2 or more than 2 surviving children. So for such kind of women who are having 2 or more than 2 surviving children, the raised benefit is restricted up to 12 weeks only. Similarly, for all commissioning mothers or all women who are adopting children up to 3 months of age, the maternity benefit period has not been enhanced. It remains at 12 weeks only. So the answer to this question is not 26 weeks but 12 weeks only, right? Next, what is the share of a woman representatives in the advisory committee to be constituted under the Equal Remuneration Act 1976? See, very simple questions, straightforward questions have been asked from the Labor Acts. So there is a constitution of advisory committee, right? And it is constituted by appropriate government. And for what purpose it is constituted? Just to increase the employment opportunities for females. And what is the composition which is stated in the act? That is, at least there should be 10 persons, half of which shall be women. So the correct answer to this question is A, 1/2 of the total members, right? Next question. The International Labour Organization Convention number 102 on minimum standards of social security was adopted in the year. So which of the following year you have to tell? So it was adopted in the year 1952. So the correct option is C. Next, in case of permanent total disablement, which one of the following is the minimum compensation to be paid under the Employees Compensation Act 1923? Okay, so all of us know here that in case of death, what is the minimum compensation which has been prescribed? 1,20,000. In case of permanent total disablement, the minimum compensation is 1,40,000. And so the straightforward answer is here 1,40,000. That is option B. Okay. Next, which of the following statements with regard to Section 1 of the Employee State Insurance Act 1948 is or are not correct? So Section 1, if we are talking about ESI Act, basically what does it talks about? It talks about short title, extent, commencement, applicability of the act. So clearly it says that the ESI Act is applicable to all factories, including factories belonging to government, except seasonal factories. Okay, so statement one is correct. Second statement, the applicability of the act in an establishment ceases if the number of persons employed therein falls below the limit specified under the act. See, it is with respect to all labor acts, once applicable, always applicable. So even if the threshold, whatever is prescribed under a particular act, the number of employees reduces below that threshold, it does not matter. The act would remain applicable. So statement 2 is incorrect, right? So they are asking about not correct statement. So the correct answer to this question is B, 2 only. Okay. Next, as per the doctrine of added peril as applied to Employees Compensation Act, a workman cannot hold his employer liable for the risk if at the time of accident the employee. So 4 of the options are given. So we must know this doctrine of added peril. Added peril talks about a situation wherever the employee outperforms his duty, which is basically not required, and it involves extra danger, right? So in that case, the employer is not liable to pay him any kind of compensation for the injury suffered by that person for conducting that particular act. Okay, so clearly A is the correct option to this question. Undertakes to do something which the employee is not ordinarily required to do and involves extra danger. Okay. Next, which of the following form part of the principles concerning the fundamental rights as per ILO's constitution? So basically here in this question, they are asking you about ILO's Declaration on Fundamental Principles and Right at Work, which was adopted in 1998, right? and it envisages basically universal principles. And what were those principles? Freedom of association and recognition of right of collective bargaining. And then there was principle which is mentioned that is elimination of forced labor, and then abolition of child labor, and the last but not the least is elimination of discrimination in respect of employment and occupation. Okay, so what uh, what does it contain then? 1, 2 and 3, right? 1, 2 and 3. Prevention of major industrial accidents, that was not the part of the principle. Okay, so the correct option is B, right? Okay, who out of the following do not fall in the definition of unorganized workers under the Unorganized Workers Social Security Act 2008? So basically, when we go through the definition of unorganized worker under this act, we will find that unorganized workers will cover self-employed workers, wage workers also, and home-based workers. Okay, so home-based workers are basically those workers which are sitting at their home, or they are doing work at any other place which is not belonging to the employer. So all these categories belong to unorganized worker. So the correct option to this question is D. Who among the following use the phrase collective bargaining for the first time? So this question is even their favorite. They have asked this question many times in various recruitment tests. So quite simple. Sydney and Beatrice Webb is the answer to this question. Okay, and there's a book named Industrial Democracy which got published in 1897 by them, right? So the correct option to this question is A. Who among the following propounded the bargaining theory of wages? So bargaining theory of wages, quite known to theory, and it is given by John Davidson. So according to this theory, whatever is the wage or price for the labor, that is determined by the bargaining powers of the workers and employers. Okay, so the correct option is D. Next question. As per the ID Act 1947, an interim or a final determination of any industrial dispute or of any question relating thereto by any labor court, industrial tribunal or national tribunal, and includes an arbitration award made under section 10A can be termed as what? Award, bipartite settlement, judicial agreement, conciliation. So simply a definition has been asked from ID Act. So definition from various labor acts, that is again a very important concern. That's a favorite concern of the examiner, right? So the answer to this question is award. So what does it include? Interim or final determination given by labor court, industrial tribunal, national tribunal, and it also includes arbitration award, which is given as per voluntary arbitration, right? Okay. Right to collective bargaining between employers and workers in India is which kind of right it is? Constitutional right, voluntary under labor law, obligatory under labor law, or fundamental right? So basically it is neither a fundamental right nor a constitutional right. It's voluntary under labor law. So this is the correct option. B is the correct answer, right? So if we have to talk about collective bargaining, what actually it is? Collective bargaining is it's a settlement by way of mutual discussions or agreements, right? And that too without the intervention of the third parties. Okay, so it's voluntary under the labor law. So if one wants to go for amicable settlement without involving the third party, they can resort to collective bargaining. Okay, next question is voluntary arbitration is a statutory recognized mode of settlement of dispute under which of the following acts? Okay, so the answer to this question is Industrial Dispute Act 1947. That is B option. And one more thing I would like to highlight here is that earlier the voluntary arbitration was not the part of the original act. It was made a part through amendment in 1956 by inserting section 10A to the act. Okay, clear?
Okay, so the next question is, according to Kurt Lewin, which one of the following is not the basic mechanism for managing change? Composition, unfreezing, changing, refreezing. Oh, it's a very easy question because I guess everyone is aware of the 3 stages of change management given by Kurt Lewin. What are these stages? Unfreezing, moving to new level, or we can call it changing, or we can call it movement as well. All right, and the last one is refreezing. So basically these 3 options are given here. So composing is not one of the basic mechanism of managing change according to Kurt Lewin. All right, next question. So the correct option is A. Next question. Which one among the following was the earliest school of organization theories? Human relations, systems, behavioral science, or the contingency school? So here, human relations school was the earliest school of the organization theories. Next question. Which one of the following statements about human resource planning is not correct? All right. A, job analysis is a systematic investigation of tasks, duties, responsibilities of a job. Job description is organized, factual statement of duties and responsibilities of job, specific job. Job evaluation is a systematic and orderly process of determining job summary, title, supervision, working. No, this is actually incorrect. Why? Because job evaluation is basically telling about the worth or the value of a job. All right, so this statement is actually regarding the job analysis, and this is not regarding job evaluation. All right, who among the following developed the multi-management technique of management development program? Very easy one. Charles P. McCormick. McCormick, he actually developed the multi-management technique of management development program. So what is this multi-management technique he gave? It is actually a system in which the permanent advisory committees of managers are made. What do? They study the problems of the company, and finally make recommendations to the higher management. So basically it is also called as a junior board of executives. So this is also called as junior board of executives. This multiple management thing. So option A is the correct answer for this. All right, next question. Which one of the following is the human resource management responsibility of line managers? All right. Develop personal plans showing promotable employees, prepare training materials, orientation documents, assist job analysts by listing specific duties and responsibilities of the job in question, conduct of job evaluation procedures. No. Option number C is here the actual responsibility of the line managers. Now, who is a line manager? Line managers are basically the first layer of managers, or the first layer of managers above the frontline workers. So what do? They basically specify the duties and responsibilities of the job, the specific job or the job in question. All right. So option number C is the correct answer for this. Next question. Sensitivity training is imparted to improve which one of the following skills of the managers? Very easy one. The option number A is the correct one. So what is sensitivity training? Sensitivity training is about making people understand about themselves and others reasonably. So this is basically the definition, or you can say the basic meaning of sensitivity training. So this is basically how the employees should, how they should create an understanding about themselves, their behaviors, their feelings and emotions, and the other employees or the colleagues of their colleagues. All right. So this is also known as social sensitivity. So basically social sensitivity is actually developed in them, and the motive is to get the behavioral flexibility so that they can actually get adjusted to the environment, to the attitudes and the behaviors of the other employees as well in the work environment. So option number A is the correct answer. All right, next one. Which one of the following is not included in the development of HDI, Human Development Index? It is also very easy one. So which one all? Per capita, employment growth rate, literacy rate. See, per capita index, literacy rate, and life expectancy. These are the basically, these three are the composite HDI index. Next question. Which one of the following is correctly matched? All right, conglomerate, a management game where the participants are instructed to perform. No, conglomerate is basically a business, what we call a business model. It is basically a corporation made of different or some unrelated businesses. So conglomerate is not correctly matched. All right. In basket exercise, what is given? A testing method based on measuring performance on actual basic job tasks. No, I guess you must have read about it everywhere in your HROV books. In basket exercise is basically in this multiple, basically a set of emails, memos, notes, etc. is being given, and the employee has to choose one, and he has to prioritize the decision being the decision that he would take upon the specific issue being given in that particular email or note or that memo. All right, so this is the in basket technique. So accordingly, this is also incorrect. Now, assessment centers used increasingly as a selection tool. Yes, it is true, because assessment centers are used to select and then train the talent. All right. So this is correct one. Work sampling itself, becomes incorrect because we have found the correct answer already. So work sampling basically is what? It is basically a technique of getting facts about the utilization of machinery or the human beings through observations which have been made randomly at different time intervals. So work sampling is that. So evidence explanation is also not related to what work sampling actually is. So the correct answer is C, option number C. All right, so the next question is, who among the following opine that natural justice is a great humanizing principle intended to invest law with fairness and to secure justice, and over the years it has grown into a widely pervasive rule affecting large areas of administrative action. So this statement basically was given under the Maneka Gandhi versus Union of India case in 1978, and it was given by Justice P.N. Bhagwati because he was the one who was one of the bench members in that case. So the statement about natural justice was given by P.N. Bhagwati, Justice P.N. Bhagwati. All right. So the correct option is D. 30th. Which of the following rules constitute the basic principles of natural justice? All right. Number 1. No one shall be a judge in his own case. Yes, true. All right, next is no decision shall be given against a party without affording him a reasonable hearing. Reasonable hearing. Yes, it is correct. And third one, quasi-judicial inquiries must be held in good faith without bias and not arbitrarily and unreasonably. It is also true. So basically, the above two principles were the basic principles of natural justice, and this one has been lately been added to the principles of natural justice. Nowadays, some 4-5 basic principles are being considered about natural justice. So all three are correct. So option number D is the correct answer in this case. All right. Next question. In which of the following cases did the Supreme Court summarize the principles on the recording of reasons by a decision-making authority? All right. Supreme Court actually gave this judgment that basically the Supreme Court highlighted the importance of giving reasons while passing a judgment or an order by any judicial or a quasi-judicial body. All right. This was given in this case of Kranti Associates Limited versus Masood Ahmad Khan case in 2010. Alright, so this was option number D.
Okay, next question is, under which of the following act the registration of a trade union is void according to the Trade Union Act 1926? So three of the acts have been mentioned here, and this is the simple most answer. The Trade Union Act specifically provides that registration of a trade union under these three acts would be considered as void. So which of these acts are there? Societies Registration Act, Cooperative Society, and Companies Act 1956. So Companies Act 1956 is no more there. Now it is replaced by 2013 Act. Okay, so the correct option to this question is C. Next, what is the maximum aggregate fine provided in the Trade Unions Act 1926 for continuous failure by a trade union to submit returns under the Act? So they have asked the question from the penalty even, right? So if you are going to ask me, I would have left this portion of learning all the penalties. So one or two questions are expected, but that cannot be done at the cost of other provisions which are laid down in the labor acts, right? So on workers, I must tell you one more thing, that on workers always the amount of penalty is quite small as compared to the employer's penalty, right? So what does returns constitute under Trade Union Acts? That rules or statement of receipts and expenditures of any trade union. These are the returns. So if you are not going to submit, then there would be a penalty. Okay, so the amount is quite negligible, that is ₹5. And for continuous default of this non-submission, then there is a prescribed penalty of ₹5 per week, and the maximum fine which can be levied is ₹50. So that is why the answer to this question is 50. Okay, next, according to Trade Union Act 1926, for which one of the following purposes the general funds of the registered trade union may not be spent? So there are two types of funds which are prescribed under the Trade Union Act. One is general fund and the other one is political fund. So general fund, if you are talking about general fund, so that can be spent. Yes, A part is correct. The conduct of trade disputes on behalf of the trade unions or any of its members. So general fund can be spent for this purpose. Next is the compensation of members for loss arising out of trade disputes. Yes, it can be spent on that account also. The maintenance of any person who is member of any legislative body constituted under the constitution or any local authority. Basically, this is the purpose which is prescribed under the objectives of political fund, right? So political fund can be used for this purpose. So basically this kind of fund is prescribed for the promotion of civic and political interest of the members, right? So the answer to this question is C. Okay, next question. Which one of the following is not a ground for the cancellation of registration of a registered trade union under the Trade Union Act 1926? Again, it's a very simple, straightforward question. Whenever there are certain grounds which have been mentioned in the Trade Union Act for cancellation of registration by the registrar of trade union. So first ground is that whenever the application is made by the trade union. Second is whenever the registrars found that the certificate has been obtained by the trade union on account of fraud, or it thinks that trade union has ceased to exist. So, and in 2001 there was amendment in the Trade Union Act wherein it is prescribed whenever the RTU ceases to have requisite number of members, then also, of course, it's a contravention of the provision of the act, right? So then also the registration would be liable to cancellation. Okay, so looking at the options, certificate of registration has been obtained by fraud. Okay, so this is a ground. Trade union has contravened the provisions of the act, so this is also the ground. An application has been made by the trade union for cancellation of its registration, this is also the ground, so this is not the ground. The general body of the trade union has shown no confidence in the office bearers. Okay, so the correct option to this question is C. For registering a trade union under the TU Act 1926, which of the following is the minimum number of workers required to be employed in the establishment with which it is connected? Very simple, straightforward question. Everyone knows that for registration of any trade union, what is the prescribed number that is stipulated in the Act? 10% or 100 of the workers, whichever is less, subject to minimum of 7. Okay, so the correct option is B. Next question. Who among the following is empowered to make regulations under the Trade Union Act 1926? Basically, in the act, it has been said that appropriate government is empowered to make regulations, right? So if we are talking about appropriate government, then it means central government and state government. So central government for which kind of trade unions? Whose object is not confined to one state, right? And for any other trade union, state government is the appropriate government. So the correct option to this answer is C. It means both state government and central government. Okay. Consider the following trade unions: CITU, AITUC, INTUC, HMS, BMS. So we need to arrange them in correct chronological order based on the year of their formation. So in such questions, we must also check whether the word ascending or descending is given. So they may also give confusing options, right? So, and one more thing, this is a repeat question. Same question has been asked in 2015 attempt also. Okay, so if we are talking about this question, the correct option is 2, 3, 4, 5, 1, that is C. So in real terms, if we talk about AITUC, that was formed in 1920. INTUC, that is Indian National Trade Union Congress, that was formed in 1947. Okay, Hind Mazdoor Sabha, HMS, that got formed in 1948. BMS stands for Bharatiya Mazdoor Sangh, that got formed in 1955. And CITU, that is Center of Indian Trade Unions, that got formed in 1970. Okay, so the correct option is 2, 3, 4, 5, 1, that is C, right? Which one of the following is the name of the newspaper started by N.M. Lokhande? So again, it's a very simple question from industrial relations. N.M. Lokhande started a very popular newspaper that is known by the name Deen Bandhu. Okay, and in 2005, this person is so important in industrial relations that Indian government also issued a postage stamp with his photograph in the year 2005. Okay, fine. So he was a popular worker leader. Along with that, he was also a journalist. Okay, so the correct option is A. Second international, which grew under the influence of socialist philosophy during 1889 to 1916, was organized in. So basically, Second International is a organization at international level. So it was formed in Paris in July 1889, right? So Paris is the right answer. What was the purpose of this Second International? To unite all the socialist parties of the various countries. Okay. So the correct option to this answer is A. Next, which one of the following was originally formed to give Indian representation to ILO? So there was a trade union, All India Trade Union Congress, which actually was formed in the year 1920. So it was formed in 1920, and it basically gave the Indian representation to ILO. Okay, so the correct answer is C. Next, who among the following was the founder president of the International Trade Union Confederation? So sometimes they ask questions from international industrial relations, international trade unions. So the name of the founder president of this ITUC that is International Trade Union Confederation, is Sharon Burrow. She was the founder president. Okay, so the correct option is B, right? Which one of the following does not come under the jurisdiction of Labor Code under the Industrial Dispute Act 1947? Okay, so under the Industrial Dispute Act, there are various schedules which are given, and out of those schedules, there are two schedules which are talking about jurisdiction of labor courts and jurisdiction of industrial tribunals, right? So schedule 2 talks about jurisdiction of labor courts, and schedule 3 talks about jurisdiction of industrial tribunals, right? So if we are talking about jurisdiction of labor courts, so whatever is order passed by the employer under the standing order, that comes under the jurisdiction of labor court. Okay, interpretation of standing order, that comes also under the order passed by the employer. Okay, regarding this D option, it has been stated whenever there is a matter which is concerning discharge or dismissal of any workman, including his reinstatement. Okay, reinstatement wherein the workman has been discharged or dismissed wrongfully, so that is also under the jurisdiction of labor code. So the only this part is left, so it means the correct option is B, because they are asking which of these does not come under the jurisdiction of labor code. Okay, next question. Very straightforward question again they are asking. Look at the easiness of the question they are asking from labor laws specifically. Which one of the following is a rate of compensation in case of layoff under the Industrial Disputes Act 1947? So 3-4 acts, they are in the mind of the examiner while setting the paper, because they are important from the economy point of view also, right? So what is the rate of compensation which is prescribed in case of layoff? That is 50% of basic wages and DA. So the correct option to this question is A. Next question. According to the Industrial Disputes Act 1947, temporary closing down and permanent closing down of a place of employment are respectively referred to as. So do not get confused here. Firstly, they are asking about definition which states temporary closing down. The another one is asking you about permanent closing down, right? So again, these kinds of definition are very significant. Okay, so temporary closing down is always lockout. Whenever we are talking about permanent closing down, it refers to closure. So don't get confused in between the options C and D, right? Okay, and regarding lockout and strike, I must tell you that there's a one basic difference between lockout. Lockout is always from the side of employer. Okay, he refuses to give work to the workers, whereas strike is the weapon in the hands of the workers. Okay, so the correct option is C here. Next question. To which one of the following types of establishments the provisions of layoff under Chapter 5B of the Industrial Disputes Act 1947 are not applicable? Simply, there are two chapters under Industrial Dispute Act, that is Chapter 5A and 5B, right? So Chapter 5A is more general in nature, and while we compare Chapter 5B with the Chapter 5A, Chapter 5B is having more stringent provisions as compared to Chapter 5A, because it is for big industrial establishments, right? So basically, Chapter 5B is applicable to those industrial establishments wherein 100 or more workers are employed, and Chapter 5A is applicable to those industrial establishments where 50 to 99 workers, up to 99 workers are employed, because for 100 and more workers, Chapter 5B gets applicable. So they come under the purview of bigger industrial establishments, right? So both of these chapters, they are applicable to plantations, mines, and factories. None of them is applicable to hotels. So the correct option to this question is C, hotels, right? Next question. As per the Industrial Disputes Act 1947, an employer cannot change the condition of service specified in 4th schedule of the Act without giving notice, and within how many days? So again, a very straightforward question. It simply says that whenever the employer wants certain conditions of service which are specifically mentioned in the 4th schedule of the Industrial Dispute Act, then the employer can do so only by serving at least 21 days of such notice. So the correct option is B. Next. Okay. According to Industrial Dispute Act 1947, which of the following cannot be raised as an industrial dispute by a trade union of workers? So, which cannot be raised as industrial dispute? Stoppage of annual increment, denial of promotion, recognition of trade union, discharge of a probationer. So basically, these three can be raised as industrial dispute. Sorry, these three: stoppage of annual increment, denial of promotion, and discharge of a probationer. Why recognition? Basically, if you're talking about recognition, then it is different from registration of trade union. Recognition is basically a process through which employers are forced to accept a particular trade union to give a representative character to a particular trade union, right? So this cannot be raised as an industrial dispute. Okay, next question. Keeping in view the scheme and object of the Industrial Disputes Act 1947, which one of the following statement is not correct? Okay, again the question is from ID Act. The Act puts restriction on the rights to close an industry covered by the Chapter 5B of the Act. Yes. So Chapter 5B, as I told you earlier also, it provides more stringent provisions for layoff, retrenchment, and closure. So if any industrial establishment which is covered under Chapter 5B, they need to seek permission before doing any such act, right? So yes, it puts restriction on the right to close an industry. So take the permission from the government and then you can proceed. B is saying under the Act, a dispute relating to dismissal of a workman cannot be treated as an industrial dispute without the support of a trade union of workers. Okay, we are leaving for it this thing for a timing. Going to C part, the main aim of the Act is to provide for investigation and settlement of industrial disputes. This is very simple, all logical. D, the Act makes provisions for prohibition of strikes and lockouts. Yes, there's a separate chapter under this Act which covers provisions related to prohibition of strikes and lockouts. Coming on to B point again, this says a dispute relating to dismissal of the workmen cannot be treated as an industrial dispute without the support of trade union of the workers. Whereas the ID Act says whenever any employer discharges, dismisses, terminates, or retrenches any worker, then that dispute shall be deemed to be industrial dispute even if no workman or union is the part of that industrial dispute. So by this, B is not correct. Okay, next. Which one of the following actions does not qualify as strike within the meaning of Section 2Q of the Industrial Disputes Act 1947? Now coming on to the definition of strike. So all of these sounds to be strike, pen down, stay in, go slow, tool down, no doubt. But how would you go for this question in ruling out that which does not qualify strike as per the meaning of strike under the ID Act? I'll just give you a hint to look at the definition of strike under the Act. It says cessation of work by a body of persons acting in combination So this definition itself is very important. Persons acting in combination or concerted refusal. Okay, and this is also cessation of work. Cessation of work by a body of persons acting in combination, or there's a concerted refusal or refusal under common understanding. Common understanding, CU I'm writing. Okay, by any number of persons who have been employed by the employer. Now, this very definition will give you the hint for this answer. Pen down, you are refusing to do the work. Stay in, you are going to the work, but still you are refusing to do any kind of work for the employer. Tool down, again you are putting your tools down and doing nothing for the employer. Go slow is a tactics which is used by workers to slow down the pace of the production. Okay, so this, in go slow, we do not refuse, we simply just slowing down the production process. And in many labor law cases, this go slow tactics is even regarded by courts as serious misconduct on the part of the workers. Do not forget this. So that does not amount to strike. Okay, clear? So the correct option to this question is C. So if you look at the components of the definition part, sometimes you can get the right answer. To which of the following industrial establishments Chapter 5B of the Industrial Dispute Act 1947 applies? So I have told you in previous two questions also, Chapter 5B is applicable to those industrial establishments employing not less than 100 workers. So the correct answer to this question is A. 52nd question. Which one of the following is not true with respect to strike and lockout in a public utility service under the Industrial Dispute Act 1947? So the statement one is strike and lockout are not permissible during the pendency of any conciliation proceedings. Okay, notice regarding strike and lockout needs to be given within 8 weeks before striking or lockout. By the way, this statement is incorrect, because what is the notice period before going to strike or lockout? That is 6 weeks, not 8 weeks. Okay, so third and fourth, they are correct. Employer shall send intimation of lockout to the appropriate government. Fourth says no employer shall lock out any of his workmen before the expiry of the date of the lockout specified in the notice. Okay, so the correct answer to this question is B. Okay, or we can say that statement B is incorrect. Next, which one of the following is the maximum number of members of the grievance redressal committee constituted under the ID Act 1947? Right, so basically there was an amendment in 2010. So this amendment also brought significant provisions to Industrial Dispute Act 1947. One of the significant provision was constitution of grievance redressal committee. Okay, and what is the maximum number of members which are prescribed for this committee? That is 6. So very straightforward question if one is aware of the 2010 amendment. Okay, which one of the following is not an adjudicatory body under the Industrial Dispute Act 1947? So everyone, if we are aware of the provisions of the Industrial Dispute Act, we know that adjudicating authorities are Labor Court, Industrial Tribunal and National Tribunal. Okay, fine. So court of inquiry, basically it's a fact finding machinery which is used, which is referred to by the government whenever there is a failure of conciliation proceedings, right? So the correct answer to this question is B. Next is, under the Industrial Dispute Act 1947, within which time period from the publication of an award of an industrial dispute to which the appropriate government is a party, the appropriate government shall make an order rejecting or modifying the award. So whenever there is, whenever the appropriate government wants to reject or modify the award, the time limit prescribed is 90 days. Okay, 90 days. So correct option is C to this question. Next, as per the Payment of Wages Act 1936, in case of termination of employment by the employer, wages earned by the person shall be paid before the expiry of how much time period? So simply it is mentioned in the Act for establishments which are employing less than 1,000 workmen, 7th of the following month is the day. For other cases, 10th of the following month is the day for payment of wages. And in case of termination of the employment by the employer, the wages should be paid by the second working day after the date of such termination. So the correct option to this question is D. As per the Payment of Wages Act 1936, which one of the following is the total amount of fine that can be imposed on any employed person in one wage period? This question has been asked many times in various recruitment tests. Very simple, straightforward question and very favorite question of the examiner. So the fine limit is 3% of the wages payable to him in respect of that wage period. So answer to this question is C. Next question is, which one of the following is not included in wage under the Payment of Wages Act 1936? Again, a question from definition part. We need to stress while going through various definitions, we must check out that what are the inclusions and what are the exclusions from the definitions of the various labor laws definitions. Okay, so different wage definitions are prescribed under different acts. Okay, so any remuneration payable under any award or settlement, that is included. Any sum paid to the employed person to defray special expenses entailed on him by the nature of his employment, that is excluded. So basically the correct option to this question is B. The other two, any remuneration to which the person employed is entitled in respect of overtime work, that is included. Or any sum which is paid to the person employed is entitled under any scheme, that is also included. So what do you mean by defrayed special expenses? Whenever the expenses incurred by the employee on behalf of the employer while performing his duties, that is in the nature of defraying special expenses to the employee by the employer. Okay. Okay, next question is, all the realizations by way of fines under the Payment of Wages Act 1936 shall be spent only for development of the factory or establishment, relief operations, community welfare, such purposes beneficial to the persons employed in the factory or establishment. Although this question is very straightforward and is being asked directly from the Act, Payment of Wages Act, but one can also infer the answer out of logic as well, that whatever is the realization by way of fines, for what purpose it should be used? It should be used for such purposes beneficial to the persons employed in the factory or establishment. Correct? So correct answer is option D. Next, which one of the following is not an authorized deduction from wages of an employed person under the Payment of Wages Act 1936? Again, a straightforward direct question from the Payment of Wages Act. So which is not the authorized deduction? So again, if we go by logic, even if you have not gone through the act, you can infer out from the options that if you're talking about income tax deduction, so that's the authorized permissible deduction, right? So deduction of income tax payable by employed person, that's the authorized deduction. Deduction for damage or loss of goods expressly entrusted to the employed person for custody attributable to his neglect. So if something goes wrong because of the reason of employee himself, then that is also the authorized reduction, right? A part says reduction for contribution to any insurance scheme. So if the employer is deducting the amount on account of insurance, that is also authorized. So the only option which is left is reductions for contribution to employer welfare fund. So employer welfare fund, the employee does not have to contribute towards that. So that is not the permissible deduction, right? So again, the option to the this question is D, right? Again, a very straightforward question from Payment of Wages Act itself. Fine imposed under this act is recoverable in How many installments? In one time basis, or 2 installments, 3 installments, 4 installments? So the correct option is one time basis. So no installments can be there for imposing a fine under the act.
ओके, नेक्स्ट क्वेश्चन, मिनिमम वेजेस फिक्स अंडर मिनिमम वेजेस एक्ट इज डिटरमाइंड बाय, ठीक है। तो इस क्वेश्चन में थोड़ा सा बैकग्राउंड है कि कमिटी ऑन फेयर वेजेस आई थी, कमिटी ऑन फेयर वेजेस बनी थी विच इज इन 1948। इट डिफाइन 3 काइंड्स ऑफ वेजेस विच आर लिविंग वेजेस, फेयर वेजेस एंड द मिनिमम वेजेस, ठीक है। तो ऑर्डर जैसा कि हम बता सकते हैं कि दिस इज मिनिमम, दिस इज मैक्सिमम, सो दिस इज डिक्रीजिंग, ठीक है। तो स्पेसिफिकली जो डिफरेंस था वो ये था कि जो लिविंग वेज है वो केवल आपको सस्टेनेबिलिटी ना प्रोवाइड करे विच इज फूड वाटर एंड शेल्टर, बट इसके साथ साथ जो भी फ्रूगल कंफर्ट ऑफ लाइफ होते हैं वो भी आपको प्रोवाइड किया जाए, फॉर एग्जांपल एजुकेशन फॉर चिल्ड्रन, इंश्योरेंस और सम काइंड ऑफ लेजर एक्टिविटीज। सो फॉर दैट लिविंग वेज वाज डिफाइंड, ठीक है। बट एक चीज उसमें ये स्पेसिफिकली कही गई कि ये वो वेजेस हैं, ये उस तरीके से इसमें 2 कंसिडरेशंस को हमें लेना पड़ेगा, विच इज फर्स्ट विच इज कि नेशनल इनकम उस टाइम पे कंट्री की क्या है, सेकेंडली जो इंडस्ट्री है उसकी कैपेसिटी टू पे क्या है, ठीक है। सो उसी तरीके से लिविंग वेज और फेयर वेज जो कि लिविंग वेज से कम होगा, इसके बीच का इन दोनों चीजों को डिफाइन किया गया। जो मिनिमम वेज थी उसमें जो स्पेसिफिक पॉइंट था कि ये तो वो पैसा है जिसमें हम नहीं करेंगे इररिस्पेक्टिव ऑफ द कैपेसिटी ऑफ एम्प्लॉयर टू पे, ये तो आपको पे करना ही पड़ेगा। सो करेक्ट आंसर इज ऑप्शन बी, ठीक है। हम आगे बढ़ते हैं। 63 question, the concept of national floor level minimum wage was mooted and recommended by, it was recommended and mooted and recommended by National Commission on Rural Labor in 1991, ठीक है। क्यों ऐसा हुआ गया? टू प्रोवाइड द यूनिफॉर्मिटी ऑफ मिनिमम वेजेस अक्रॉस द कंट्री, क्योंकि हर एक स्टेट अपना मिनिमम वेज अलग रख रहा था, ठीक है। ओके, नेक्स्ट क्वेश्चन, द मिनिमम वेज 1948 was enacted for the purpose of fixing, ठीक है। तो जो मिनिमम रेट्स ऑफ वेजेस है ये तो फिक्स करने के लिए था ही, बट ओनली इन शेड्यूल एम्प्लॉयमेंट। व्हाट इज शेड्यूल्ड एम्प्लॉयमेंट? शेड्यूल्ड एम्प्लॉयमेंट वो होते हैं कि किसी भी एक्ट के लास्ट में एक शेड्यूल दिया जाता है जिससे रिलेटेड सारी चीजें उसमें एप्लीकेबल होंगी, तो दैट इज व्हाई द यूजेज ऑफ द वर्ड शेड्यूल्ड, ठीक है। हम आगे बढ़ते हैं। Next question, out of the following which norm was recommended in the 15th session of ILC for fixing of minimum wages? So ILC जैसा कि आप जानते हैं, it is a tripartite body जिसमें सरकार, ट्रेड यूनियन रिप्रेजेंटेशन एंड एम्प्लॉयर रिप्रेजेंटेशन तीनों पार्टिसिपेट करते हैं, ठीक है। और ये 15 सेशन 1957 में था, which was very important session for minimum wages। उसमें कुछ चीजों को डिटरमाइन किया गया, जो रिकमेंडेशन दी गई। एक तो ये एकदम करेक्ट है, एजुकेशन मेडिकल रिक्वायरमेंट टू कंटेन 25% ऑफ मिनिमम वेजेस, ये गलत है। क्लोथिंग रिक्वायरमेंट टू बी एस्टिमेटेड 18 यार्ड्स पर एनम, और 4 आदमी के हिसाब से 72 यार्ड्स, ये सही है। फ्यूल लाइटनिंग अनदर मिसcellaneous आइटम टू कॉन्स्टिट्यूट 20% ऑफ टोटल मिनिमम वेज, ये भी सही है। तो बेसिकली ऑप्शन बी रिकमेंडेशन का पार्ट नहीं था, ये 1991 में सुप्रीम कोर्ट ने ये ऑब्जर्वेशन दिया था कि इस तरीके से मिनिमम वेजेस में कंसिडरेशन भी आना चाहिए। सो करेक्ट आंसर इज ऑप्शन बी, ठीक है। हम आगे बढ़ते हैं। As per the minimum wage 1948, the rate of minimum wages which are finally notified in the official gazette and unless such notification provides come into the force after the expiry of which of the following period from the date of its issue, ठीक है। तो हमेशा जो नोटिफिकेशन होता है या तो उसमें कोई डेट दी जाती है या फिर वो विद इफेक्ट एक्ट में वो लैंग्वेज दी जाती है, और इस एक्ट में जो टाइम पीरियड दिया गया था वो था 3 months। तो करेक्ट आंसर इज ऑप्शन सी। हम आगे बढ़ते हैं। The review of the minimum wages rate fixed under the Minimum Wages Act 1948 should not exceed। तो एक्ट में साफ साफ मेंशन है कि जो रिव्यू हो, जो रिवाइज हो रहा है, वो 5 साल से ज्यादा के अंतराल में नहीं होना चाहिए। दैट इज व्हाई द करेक्ट आंसर इज ऑप्शन बी। नेक्स्ट क्वेश्चन, which of the following is are not included under the definition of wages in the Minimum Wages Act 1948? 2015 में भी wages से related question आया था, but थोड़ा सा डिफरेंट था और इसी एक्ट की वेजेस पूछी गई थी, ठीक है। द वैल्यू ऑफ एनी हाउस अकोमोडेशन, ये इंक्लूडेड नहीं है, सही बात है। एनी कंट्रीब्यूशन पेड बाय एम्प्लॉयर टू एनी पेंशन फंड और प्रोविडेंट फंड, ये भी इंक्लूडेड नहीं है, सही बात है। एनी ट्रेवलिंग अलायंस, ये भी इंक्लूडेड नहीं है। तो इस क्वेश्चन के हिसाब से जो कि हमें नॉट बताना है, करेक्ट आंसर हो जाएगा ऑप्शन डी, ठीक है। हम आगे बढ़ते हैं। Under the Contract Labor Regulation and Abolition Act 1970, the total number of members of the Central Advisory Board other than the chairman and the chief labor commissioner central shall not exceed। यही क्वेश्चन 2015 में भी कुछ लैंग्वेज चेंजेस के साथ आया था। तो इसमें जो नॉमिनेटेड मेंबर्स होते हैं वो 11 से 17 हो सकते हैं, यानी मैक्सिमम नंबर इज 17। तो करेक्ट आंसर इज ऑप्शन डी, ठीक है। आगे बढ़ते हैं हम। कॉन्ट्रैक्ट लेबर एक्ट इज ऑल्सो एप्लीकेबल टू एस्टेब्लिशमेंट्स। तो ये क्वेश्चन स्पेसिफिकली एप्लीकेबिलिटी के बारे में पूछ रहा है। एप्लीकेबिलिटी हमेशा सेक्शन 1 में दी जाती है किसी भी एक्ट के। तो अ मिनिमम ऑफ 50 वर्कमैन, नो, इट इज 20 वर्कमैन। सो ये आउटराइटली गलत हो गया है। Work of an intermittent nature is performed for more than 120 days in the preceding 12 month. तो बेसिकली अगर 120 दिन से नीचे का इंटरमिटेंट काम होगा वो इंक्लूडेड नहीं होगा, पर 120 से ज्यादा का काम इंक्लूडेड होगा, दैट इज व्हाई ये करेक्ट है। वर्क ऑफ सीजनल कैरेक्टर इज परफॉर्म फॉर मोर देन 60 डेज इन अ ईयर। अगर लेस देन 60 डेज इन अ ईयर है तो इंक्लूडेड नहीं है, अगेन ये भी करेक्ट हो जाएगा। तो करेक्ट आंसर इज 2 and 3 विच इज ऑप्शन बी। ठीक है। Under the Contract Labour Regulation and Abolition Act, the chairman of the State Advisory Contract Labour Board is appointed by, again state से related है, तो chairman भी state government करेगा, which is option B। ठीक है, ये नहीं करेगा, ये नहीं करेगा और ये नहीं करेगा। ठीक है। Next question, as per the Contract Labour Act, what is the minimum number of contract laborers ordinary to be employed so that the employer must provide a canteen? Again ये question पिछले 2015 में भी आया था और इसका करेक्ट आंसर है 100 और मोर। ठीक है, हम आगे बढ़ते हैं। The Contract Labour Regulation Act excludes the definition of contractor one who, ठीक है, कॉन्ट्रैक्टर की डेफिनेशन जो कि सेक्शन 2 में प्रोवाइडेड थी उसकी बात कर रहा है। तो टू अंडरटेक अप टू प्रोड्यूस अ गिवन रिजल्ट फॉर एन एस्टेब्लिशमेंट थ्रू कॉन्ट्रैक्ट लेबर, ये एकदम सही है। सप्लाइज कॉन्ट्रैक्ट लेबर फॉर एनी वर्क ऑफ द एस्टेब्लिशमेंट, ओके, ये भी सही है। सप्लाइज गुड्स एंड आर्टिकल्स ऑफ मैन्युफैक्चर टू एन एस्टेब्लिशमेंट, यहाँ पे देखिए सप्लाइज गुड्स एंड आर्टिकल्स, जो केवल रॉ मटेरियल प्रोवाइड कर रहा है, क्या वो डेफिनेशन में आता है? द डेफिनेशन स्पेसिफिकली एक्सक्लूड दिस पर्सन फ्रॉम द डेफिनेशन ऑफ कॉन्ट्रैक्टर एंड हेंस करेक्ट आंसर इज ऑप्शन सी। Next question, no court shall take cognizance of an offense under Contract Labour Act except on a complaint by or with the previous sanction in writing of, किसकी बात है? इंस्पेक्टर की। इंस्पेक्टर से आपको लेना पड़ेगा। एंड व्हाट इज द मीनिंग ऑफ कॉग्निजेंस ऑफ एन ऑफेंस हियर? इसका मतलब सिंपली ये है कि उस पूरे ऑफेंस को ना रजिस्टर कर रहा है कोर्ट कि हाँ, he has taken the court has taken the cognizance of that particular incident, court has taken a note of that incident। वो तभी होगा जब आपका इंस्पेक्टर का साइन होगा। ठीक है। नेक्स्ट क्वेश्चन, पार्ट 3 ऑफ द चाइल्ड एंड एडोलेसेंट लेबर प्रोहिबिशन एंड रेगुलेशन इन 1986 डील्स विद, ओके, पार्ट 3 किससे डील करता है? पार्ट 3 डील करता है रेगुलेशन और कंडीशंस ऑफ वर्क, हेंस करेक्ट आंसर इज ऑप्शन सी। ठीक है, हम आगे बढ़ते हैं। Who among the following can appoint the inspector under the Child and Adolescent Labour Act 1986? तो कौन अपॉइंट करता है इंस्पेक्टर्स को? इंस्पेक्टर को अपॉइंट करता है एप्रोप्रिएट गवर्नमेंट। ठीक है। व्हाट इज द मीनिंग ऑफ एप्रोप्रिएट गवर्नमेंट? एप्रोप्रिएट गवर्नमेंट्स कैन बी अ स्टेट गवर्नमेंट, इट कैन बी अ सेंट्रल गवर्नमेंट। ठीक है। When we are talking about state jurisdiction, then it is a state government. When we are talking about central jurisdiction, then it is a central government. So that is why the word appropriate government has been used. ठीक है। Next question, as per the child and adolescent labor, in which of the following types of occupation a child can be employed? ठीक है, अच्छा क्वेश्चन है। तो बेसिकली चाइल्ड जो है वो एज एन आर्टिस्ट किसी भी ऑडियो विजुअल एंटरटेनमेंट में पार्टिसिपेट कर सकता है एक्सक्लूडिंग सर्कस। हालांकि ये क्वेश्चन पूरी तरीके से सही नहीं था क्योंकि इसमें एक्सक्लूडिंग सर्कस देना चाहिए था। सो करेक्ट आंसर इज ऑप्शन ए, या फिर वो किसी फैमिली या फैमिली एंटरप्राइजेस में भी काम कर सकता है। ठीक है, ओके, आगे बढ़ते हैं। Which one of the following is the maximum spread over of the daily hours of work, including interval for rest, time spent in waiting for a child in this particular act? So इसका correct answer है 6 hours। ठीक है, ऑप्शन बी। ठीक है, हम आगे बढ़ते हैं। Which of the following is not true with respect to the amendment introduced by the Child Labor Prohibition and Regulation Amendment Act 2016? ठीक है, अगर आप ऑप्शन ए देखेंगे तो आप समझ जाएंगे ये गलत है। Offenses under the act are made non-compoundable। What is the meaning of compoundable and non-compoundable? Compoundable offenses वो होते हैं जो कि कोर्ट के बाहर एज अ जो विक्टिम है वो कॉम्प्रोमाइज कर सकता है और देयर कैन बी अ मॉनेटरी सेटलमेंट विदाउट द इन्वॉल्वमेंट ऑफ कोर्ट। ठीक है, बट जो नॉन कंपाउंडेबल ऑफेंसेस होते हैं उसके लिए आप इस तरीके कॉम्प्रोमाइजेस नहीं कर सकते। व्हाई? बिकॉज ऑल ऑफ दोस क्राइम्स आर कंसीडर्ड एज अ ब्रूटल क्राइम व्हिच इज हार्मफुल टू द सोसाइटी। दैट इज व्हाई एन इंडिविजुअल हैज नो राइट to take a decision of compromise the situation. So therefore correct answer is option A। ठीक है, हम आगे बढ़ते हैं। There are 10 persons employed in a shop and therefore this particular which is gratuity act is applicable. After some time their employee resigns from the services of the shop, यानी उसके employees कम हो गए हैं। Resultantly which one of the following is the correct legal position on the applicability or otherwise of the said act? तो क्या है इसका correct answer? तो इसका correct answer है the act will continue to apply on the shop. Why? Because लेबर लॉज में ये चीज हमेशा आप याद रखिए, वंस एप्लीकेबल इट इज ऑलवेज एप्लीकेबल। ठीक है, ओके। नेक्स्ट हम आगे बढ़ते हैं। एज पर द पेमेंट ऑफ ग्रेचुटी एक्ट, व्हाट इज द रेट ऑफ पेमेंट ऑफ ग्रेचुटी इन एन एस्टेब्लिशमेंट? तो कैसे कैलकुलेट करते हैं? इट इज ऑलवेज 15 days of wages for every completed year of services, hence option C is the correct। 15 by 26 into monthly wages into number of years। ठीक है, ओके, हम आगे बढ़ते हैं। So correct answer is option C, 82। As per the Payment of Gratuity Act 1972, what is the rate of payment of gratuity in seasonal establishment? तो seasonal establishment में क्या रेट है? 7 days of wages for each season, hence correct answer is option C। आगे बढ़ते हैं। According to Payment of Gratuity Act 1974, the employee who is required to make nomination for the purpose of second provision of the section should have completed nomination कितने टाइम बाद वो fill कर सकता है? 1 year of services, hence correct answer is option D। और नॉमिनेशन किसका हो सकता है? केवल फैमिली मेंबर्स का हो सकता है। ठीक है, आगे बढ़ते हैं। क्वेश्चन नंबर 84, अंडर दिस पर्टिकुलर एक्ट व्हिच वन ऑफ द फॉलोइंग इज नॉट इंक्लूडेड व्हाइल डिप्लॉइंग द कंटीन्यूअस सर्विस ऑफ 1 year? तो कंटीन्यूअस सर्विस ऑफ 1 year जो होती है, या तो वो 240 डेज की होगी, या अगर माइंस है तो 190 डेज की होगी। तो उसके लिए बट कुछ कुछ assumptions को इंक्लूड किया जाए, कुछ कुछ छुट्टियों को इंक्लूड किया जाएगा। वो कौन सी है? पीरियड ऑफ ले ऑफ, यस। पीरियड ऑफ लीव विद फुल वेजेस, यस। पीरियड ऑफ मैटरनिटी लीव, यस। पीरियड ऑफ स्ट्राइक डिक्लेयर्ड इलीगल, ऑब्वियसली कोई भी स्ट्राइक अगर इलीगल डिक्लेयर कर दी गई है यानी वो लेजिटिमेट स्ट्राइक नहीं है, यानी वो छुट्टियां जो हैं वो काउंट नहीं होंगी कंटिन्यूअस सर्विस को जोड़ने में। हेंस करेक्ट आंसर इज ऑप्शन डी। हम आगे बढ़ते हैं। अंडर द बिल्डिंग एंड अदर कंस्ट्रक्शन वर्कर्स एक्ट, what is the minimum number of building workers ordinary to be employed so that employer is bound to provide a creche? Correct answer is option B। Again, this question is a repeat question. This question is a repeat question, and this was also appeared in the year of 2015। Okay. Safety committee is mandatory under the Building and Other Construction Workers Act if a prescribed minimum number of building workers are ordinarily employed। What is this minimum number? Again, ये क्वेश्चन भी रिपीटेड है। करेक्ट आंसर इज ऑप्शन दिल्ली विच इज 500। और जब भी ऐसा होता है तो सेफ्टी कमेटी अपॉइंट होती है और सेफ्टी ऑफिसर भी अपॉइंट होता है। ठीक है, विच ऑफ द फॉलोइंग इज आर इंक्लूडेड इन द डेफिनेशन ऑफ बिल्डिंग और अदर कंस्ट्रक्शन वर्कर्स अंडर दिस एक्ट? तो क्या क्या इंक्लूडेड है? कंस्ट्रक्शन एंड ऑल्टरेशन इंक्लूडेड है, डेमोलिशन इंक्लूडेड है, मेंटेनेंस इंक्लूडेड है, रिपेयरिंग इंक्लूडेड है, बट माइनिंग एंड क्वायरिंग नहीं है एंड प्लांटेशन नहीं है। हेंस करेक्ट आंसर इज ऑप्शन बी। ठीक है, नेक्स्ट क्वेश्चन। अंडर द बिल्डिंग एंड अदर कंस्ट्रक्शन वर्कर्स एक्ट, who among the following is appointed as the ex officio member of the state building and other construction workers advisory committee? कौन होता है? चीफ इंस्पेक्टर, जो कि सेक्शन 42 में अपॉइंट होता है बाय द स्टेट गवर्नमेंट। ठीक है, सो करेक्ट आंसर इज ऑप्शन बी। आगे बढ़ते हैं। अंडर द बिल्डिंग एंड अदर कंस्ट्रक्शन वर्कर्स एक्ट, इन ऑर्डर टू बी एलिजिबल फॉर रजिस्ट्रेशन एज बेनिफिशियरी ऑफ दिस वेलफेयर फंड, वर्कर मस्ट बी एंगेज फॉर अ मिनिमम ऑफ 90 days। ठीक है, इसलिए करेक्ट आंसर है ऑप्शन सी। अंडर द रूल्स ऑफ बिल्डिंग एंड अदर कंस्ट्रक्शन वर्कर्स एक्ट, जो कि 1998 में आए थे, व्हाट इज द मैक्सिमम वेट व्हिच कैन एडल्ट वुमन इज परमिटेड टू कैरी ओवरहेड? सो करेक्ट आंसर इज ऑप्शन सी। जो करेक्ट अगर एडल्ट है तो 55 kg। ठीक है, नेक्स्ट क्वेश्चन। द टर्म WannaCry इज एसोसिएटेड विथ, वेल ये क्या था? 2017 में ये एक साइबर अटैक था जो काफी पॉपुलर हुआ था। हेंस करेक्ट आंसर इज ऑप्शन सी। 92, the 9th BRICS summit was held in which one of the following cities? जो 9th थी वो जियामेन में हुई थी, चाइना वाज द होस्ट। 2021 में जो हुई थी वो न्यू दिल्ली में हुई है। ठीक है, अगेन करंट अफेयर्स के जो ये सवाल है इसमें आप एक पॉइंट नोट करिए कि आपको इसमें बिल्कुल ही फैक्चुअल इन्फॉर्मेशन को पकड़ना है और उसके हिसाब से अपनी तैयारी करनी है, क्योंकि यूपीएससी के एएलसी का एग्जाम हो चाहे अलग के और रिक्रूटमेंट एग्जाम्स हो, उसमें उनकी यही अप्रोच है। सो do not go very much deep into it, very much analytical about it, you just need to observe the factual information। ठीक है, next, besides India which of the following countries are members of Mekong Ganga cooperation? तो India plus 5 Asian nations जो हैं वो इसके members हैं। ठीक है, which are Cambodia, Laos, Myanmar, Thailand and Vietnam। Hence correct answer is option A। नेक्स्ट क्वेश्चन। नो इंडिया प्रोग्राम इज अ फ्लैगशिप इनिशिएटिव ऑफ विच वन ऑफ द फॉलोइंग मिनिस्ट्रीज? तो ये मिनिस्ट्री ऑफ एक्सटर्नल अफेयर्स का प्रोग्राम था जिसमें यूथ को इंडिया के वेरियस फेसेट से रिलेटेड एक टूर कराया गया था। सो करेक्ट आंसर इज ऑप्शन बी। ठीक है, कंसीडर द फॉलोइंग स्टेटमेंट अबाउट ई माइग्रेट, अ प्रोजेक्ट ऑफ मिनिस्ट्री ऑफ एक्सटर्नल अफेयर्स। इट फैसिलिटेट एमिग्रेशन ऑफ ईसीआर कैटेगरी ऑफ गोइंग टू नोटिफाइड कंट्रीज फॉर एम्प्लॉयमेंट पर्पस। यस, It is integrated with Bureau of Immigration System of Ministry Home Affairs. सही बात है. It is integrated with Passport Seva Project. ये भी सही बात है. So all options are correct. Hence correct answer is option A. देखिए स्कीम भी जो आ रही है उसके जो बिल्कुल ऑब्जेक्टिव्स हैं या फिर जो मेजर पॉइंट्स हैं उन्हीं पे फोकस करना है आपको. ठीक है. विच वन ऑफ द फॉलोइंग इज द हाईएस्ट सिविलियन अवार्ड ऑफ अफगानिस्तान? तो क्या है? आमिर अमानुल्लाह खान अवार्ड which was instituted in the year of 2006. ठीक है. नेक्स्ट क्वेश्चन, विच वन ऑफ द फॉलोइंग इज द ऑफिशियल पोजीशन ऑफ मिस ऑन्ग सैन सू क्वाई? तो ये 2017 की ऑफिशियल पोजीशन थी, विच इज स्टेट काउंसिल ऑफ म्यांमार, विच इज इक्विवेलेंट टू द प्राइम मिनिस्टर पोजीशन. करेंटली बिकॉज ऑफ सम पॉलिटिकल क्राइसिस चीजें जो हैं वो बदल चुकी हैं इन द स्टेट ऑफ म्यांमार. ठीक है. Which one of the following statement above NPR, which is National Population Register, is not correct? So correct answer is option D, which is currently digitization is being carried out by the central government. Okay. Recently, the government of India had conducted the socio-economic and caste census all over the country. Which of the following agencies had rendered complete logistics and technical support to this exercise? कौन है वो? It is Office of Registrar General and Census Commissioner India, जो कि जो census होती है, नेशनल सेंसस होती है हर 10 साल में, एक्सक्यूज मी, उसको भी कराती है. ठीक है. Paul Beatty was awarded the Man Booker Prize 2016 for which one of the following works? Okay, so Paul Beatty is an American writer. इनको 2016 में Man Booker Prize मिला था for the novel of The Sellout, which was a political satire. Okay.
Next question. 101. All right. Under which of the following grounds the Constitution of India authorizes the legislature to make laws providing for preventive detention? All right. Now, there are certain grounds which have been given under article, the Constitution article for preventive detention. So, what are these grounds? Grounds for preventive detention are, number one is security of state and maintenance of public order. Public order. All right. Next one was maintenance of supplies and services essential to the community. All right. Number three is foreign affairs or security of India. All right. So what are all options given? Security of state, yes, correct. Maintenance of public order, yes, correct. Maintenance of supplies, yes, correct. Maintenance of public health and morality, no, this is not one of the grounds of preventive detention. So the correct option would be B, that is 1, 2 and 3. All right. So next one, moving ahead. A money bill contains provisions for which of the following matters? All right. Imposition, abolition, remission, alteration, regulation of any tax, yes. The regulation of the borrowing of money by the government, yes. The custody of consolidated fund or the contingency fund of India, yes. Imposition of fines and other pecuniary penalties, no. It has clearly been given under Article 111, which is related to money bill, that nothing of sort of imposition of fines and other kind of penalties would amount to or would be considered as a money bill. It has clearly mentioned them. So option number 1, 2 and 3 are only correct, which is option number D. All right, next one. Under which of the following amendments to the Constitution of India, the age to exercise franchise, that the age to actually get the right to vote was reduced from 21 years to 18 years. All right, this was under 61st Constitutional Amendment Act. That is option number C. Very easy one. All right. Next one. Which or one of the following articles of the Constitution of India states that the state shall make provisions for securing just and humane conditions of work and for maternity relief? All right. This was under Article 42 and this is one of the directive principles of the state policy. All right. Very easy one. Direct and straightforward question. Option number B is the correct answer. Next one. Under which provisions of the Constitution forced labor, employment of children in factories or other dangerous employments have been prohibited? Very easy one. Again, you must know all the fundamental rights and the articles related to them. So the correct answer here is fundamental right against exploitation, and it comes under Article 23 and 24. All right. So option number C is the correct answer. Next one. Under which one of the following articles of the Constitution the state shall endeavour to secure by suitable legislations or in other way or in any other way the conditions of work ensuring a decent standard of life to all workers. This is also again a DPSP, Directive Principles of the State Policy. It is given under Article 43. So the correct option is option number D. Next question. In India, all powers with respect to the acquisition and termination of citizenship rest with whom? With the Parliament. All right. Article number 5 to 11 actually deals with the citizenship of India. All right. It is under part 2. These articles actually deals with who can be a citizen of India, who cannot be a citizen of India, and how the citizenship can be terminated. All right. So there are various factors which are also being given under this article. So what the question was actually asking was, who has the power with respect to the acquisition or the termination of citizenship? It is with the Parliament. All right. Option number C is the correct answer. Next question. Which one of the following is most appropriate regarding the resignation of the President of India? See, resignation of India. So how the resignation of President happens? Now, generally he has 5 years term, but in between, if he has been asked to resign or he himself wants to resign, so what he does, he addresses the resignation letter to the Vice President. Then he will communicate, the Vice President will communicate that to the Speaker of Lok Sabha. And finally, the final call will be taken by the Speaker himself of Lok Sabha. So basically, option number B is the correct answer for this. Next question. Who among the following bodies decides about doubts and disputes relating to the election of President or Vice President of India? So it is also very easy one. Everywhere it is given that the Supreme Court of India actually has the right regarding deciding about the disputes and the doubts which are related to the election of President or the Vice President. So it is the final authority, Supreme Court of India, to decide about the disputes relating to their election. All right. Option number B is the correct one. Next question. Which one of the following statements regarding citizens' right in India is not correct? All right. Fundamental rights are exclusively for the citizens. See, in one go we can mark the option as incorrect, as correct, because this statement is not correct. So the correct answer is this. Why? Because fundamental rights are there for citizens as well as for the foreigners or the aliens as well. So there are specific rights which are only for the citizens, and there are some rights which are available to both the citizens and the foreigners. So which one are the rights which are only and specifically reserved for the citizens? See, I have it is just like, just cram the numbers, and then you can obviously, if you know which article relates to which of the following, you can get it. All right. So this is article number 15, 16, 19, 29 and 30. So these are the articles which are only for the citizens. Only for the citizens. All right. So the correct option, you do not have to go to other options, do not have to waste your time, because in one go you can mark the A option as that this is not correct. So just mark it right and then move ahead, all right, without wasting a minute or a second even. So option number A is the correct answer.
Okay, next question. So we have been given this series, which is nothing but a timestamp. So the difference between these two terms is nothing but 20 minutes. This is 40 minutes. So next will be 60 minutes. So 1220 plus 60 minutes will be nothing but 1320, and therefore correct answer will be B. Next one. In a certain language, college is coded as DNNJHDI. How will foreign be coded in that language? So letter series question. If you see this, C becomes D, so +1. O becomes N, so -1. So let us try to use the same logic in our, so F plus 1. So f plus 1 will give us g, and then o minus 1. So o minus 1 will give us n. And if you look at your choices, there is only one choice जिसमें कि it starts with gn. Therefore आपको पूरा decode भी करने का जरूरत नहीं है. With this only you can do it. So correct answer is A. Next one, which of the following statement is false if A, B, C, D are to be seated in a row and C and D are not adjacent to each other and B is not at the third place. So what we have been given is that C और D एक साथ नहीं होना चाहिए. और अगर if these are the four slots, ठीक है, if these are the four slots, then on slot 3 we cannot have B. So B cannot be at third place. So इसको हमें देख के करना है कि इनमें से क्या definitely false होगा ही. So पहले वाला देखते हैं. सबसे पहले क्या है, that A is at fourth place. A is at fourth place, तो ये हो सकता है. So अगर मैं A को यहां रख दूं, ठीक है, A को मैं यहां रख दूं और C और D को इकट्ठा नहीं होना है, तो मैं C को यहां रख दूंगा, D को यहां और B को यहां लेके आ जाऊंगा. यस, ये हो सकता है. नेक्स्ट वन इज दैट A is at third place. अगर A को हम तीसरी जगह रखते हैं, ठीक है, सो A is at third place, ठीक है, हमने रख दिया. अब B और C और D को इकट्ठा नहीं होना है. So, क्योंकि C और D को इकट्ठा नहीं होना है तो मैं C और D यहां रख देता हूं और बचा क्या, B को मैं यहां रख देता हूं. तो ये भी हो सकता है. अगले वाला देखते हैं. द नेक्स्ट वन इज दैट A is at second place. तो A को अगर मैं यहां रख दूंगा, ठीक है, अब C और D को इकट्ठा नहीं होना है, इसका मतलब मैं C D को यहां रख सकता हूं और B कहां बचा, B को मैं यहां, ये भी पॉसिबल है. ठीक है, लास्ट वन देखते हैं. सो लास्ट वन इज A is at first place. सो अगर A को हम लोग यहां रखते हैं, अब C और D को इकट्ठा नहीं होना है, इसका मतलब C और D सिर्फ यहां हो सकता है. सो B के पास कोई ऑप्शन बचेगी नहीं, B तो यहीं आएगा. लेकिन कंडीशन क्या दिया हुआ है, तो B यहां नहीं हो सकता. देयरफॉर this cannot be true and D will definitely be false. आगे बढ़ते हैं. If prime numbers are assigned to English letters from A to Z, then what is order of MAT? So guys, सभी लोगों को 1 to 100 प्राइम नंबर याद होने चाहिए. एग्जाम में चेक करने के लिए तुम लोग ऐसा भी देख सकते हो कि 1 से लेके 50 तक 15 प्राइम नंबर है और रिमेनिंग 51 से 100 तक 10 प्राइम नंबर है. टोटल 1 से लेके 100 तक 25 प्राइम नंबर है, जो कि सब लोगों को याद होना चाहिए. तो 1 से सो ABCD लिखना शुरू कर दो, ABCDE एंड सो ऑन. ठीक है, और फिर एक एक करके प्राइम नंबर भी लिखना शुरू कर दो, जैसे 1 2 3 5 7 11 एंड सो ऑन. एंड देन ट्राई टू फाइंड आउट कि MAT के सामने क्या आता है. सो अगर तुम लोग इसको देखोगे, M विल बी 41, A will be, अभी हमने निकाला ये 2 and T will be 71. So 41 to 71, correct answer will be D. Next one, सिलोजिज्म का सवाल है. सो सबसे पहले क्या दिया, all pens are papers. ठीक है, सो जितने भी पेन हैं वो पेपर हैं. ठीक है, उसके बाद all papers are boats. जितने पेपर हैं वो सभी पेपर क्या हैं, बोट्स हैं. सो बोट्स विल बी दिस सर्कल, BOATS. ठीक है, उसके बाद हमें क्या दिया है कि सम बर्ड्स आर पेपर्स, सम बर्ड्स आर पेपर्स. ठीक है, अगर कुछ बर्ड हैं जो पेपर है तो सम वाले को हम इंटरसेक्ट करके दिखाते हैं. ठीक है, इसका मतलब जो बर्ड है, जिसको मैं ब्लू से करने की कोशिश करता हूं, तो बर्ड कैसे हो सकते हैं, बर्ड ऐसे हो सकते हैं, या फिर बर्ड ऐसे भी हो सकते हैं. करेक्ट, या फिर बर्ड ऐसे भी हो सकते हैं, बर्ड्स. करेक्ट, तो ये सारी पॉसिबिलिटीज हैं जिसमें बर्ड अपना हो सकता है. लेट्स लुक एट द चॉइसेस. सबसे पहला क्या है, एंड गाइस हमें वो वाला चॉइस निकालना है जो डेफिनेटली ट्रू है. ठीक है, सो सम बोट्स आर बर्ड्स, सम बोट्स आर बर्ड्स. सो तुम किसी भी सिनेरियो में जाओगे, कुछ तो बोट्स डेफिनेटली आएंगे. तुम ये वाला सिनेरियो देख लो, ये वाला देख लो, या ये वाला देख लो, क्योंकि बोट्स तो एक सुपर सेट है. और क्योंकि सम बर्ड्स आर पेन, और सारे बर्ड अपने आप में सॉरी, सम बर्ड्स आर पेन, और सारे पेन अपने आप में बोट्स हैं, तो ये तो होना ही होना है हमेशा ही, कुछ कुछ बोट्स तो डेफिनेटली बर्ड होंगे ही होंगे, देयरफॉर वन इज ट्रू। अब सेकंड है सम बर्ड्स आर पेन्स, सम बर्ड आर पेन, ठीक है। तो ये वाला जो सिनेरियो अगर तुम देखोगे, ये वाला और ये वाला, तो मैंने ऐसा सिनेरियो बना दिया जिसमें एक भी बर्ड पेन नहीं है, देयरफॉर सेकंड स्टेटमेंट इज नॉट डेफिनेटली ट्रू, सो दिस इज रॉन्ग। थर्ड वन, नो पेन आर बर्ड, नो पेन आर बर्ड, लेकिन हमने एक ऐसा सिनेरियो बना दिया है जिसमें कुछ पेन बर्ड हो सकते हैं, which is given in green, therefore this is also wrong, and therefore correct answer is A. A का मतलब only statement 1 is true, 2 and 3 are not true. आगे बढ़ते हैं। सो गाइस, सबसे आसान सवाल डायरेक्शंस वाला, A goes 5 किलोमीटर टू नॉर्थ, तो इस वाले सवाल के लिए हम क्या करते हैं, सबसे पहले हम लोग बना लेंगे नॉर्थ, साउथ, ईस्ट, वेस्ट, हम लोग अपना डायरेक्शन बना लेते हैं। एंड इसको तुम लोग पढ़ोगे तो पहले वो 5 किलोमीटर नॉर्थ गया, फिर उसने एक राइट ले लिया, फिर हो गया 3 किलोमीटर, फिर वो उसके बाद 5, फिर यहाँ गया 5 किलोमीटर, फिर उसके बाद वो 4 किलोमीटर यहाँ गया। पूछा क्या है कि और टोटल डिस्टेंस कितना है फ्रॉम द ओरिजिनल पॉइंट, तो ये वाला डिस्टेंस हमें निकालना है, तो ये कितना हो गया, ये वाला 3 और ये वाला 4, 3 + 4 7। डायरेक्शन कौन सी है ये, यहाँ से अगर हम देखें तो अगर हम यहाँ से देखें तो ये वाला कहाँ डायरेक्शन है, ये ईस्ट डायरेक्शन है, सो 7 किलोमीटर्स ईस्ट, करेक्ट आंसर इज ए। ठीक है गाइज, आगे बढ़ते हैं। कंसिडर दिस सीरीज, इससे आसान सवाल नहीं आ सकता है। बाय द वे, आई वांट टू टेल यू कि जो एएलसी के सवाल 2015 और 17 में आए थे वो काफी सारे आसान थे, लेकिन अब रिक्रूटमेंट एग्जाम में इतने भी आसान नहीं आते। अब जो न्यूमेरिकल एप्टीट्यूड के सवाल हैं वो थोड़े से डिफिकल्ट आते हैं, थोड़े से कॉन्सेप्चुअल आते हैं धीरे धीरे। और जो यूपीएससी के जितने भी एग्जाम्स हैं, जैसे कि एएलसी या रिक्रूटमेंट एग्जाम, ईपीएफओ, ईएसआईसी, एक एनुअल एग्जाम होता है सीआईएसएफ, ठीक है, सीएपीएफ, और यूपीएससी सिविल सर्विसेज सीसेट, इन सभी सवालों का डिफिकल्टी लेवल बिल्कुल सेम है। सिर्फ एक एग्जाम है जिसका डिफिकल्टी लेवल अलग है, दो एग्जाम है रादर, एक एनडीए और एक सीडीएस, उनका थोड़ा सा डिफरेंट होता है, थोड़ा हायर होता है। इसके अलावा मैंने जितने भी एग्जाम के नाम लिए हैं, ये कौन से, जितने रिक्रूटमेंट एग्जाम है, रिक्रूटमेंट एग्जाम कौन से होते हैं, एएलसी, ईपीएफओ, ईएसआईसी, एडमिन ऑफिसर, स्टोर ऑफिसर, ये जितने रिक्रूटमेंट एग्जाम्स हैं, प्लस सीआईएसएफ, प्लस सीएपीएफ, प्लस सिविल सर्विसेज का जो सी सेट का पेपर होता है उसमें, ये सारे सवाल डेफिनेटली करने हैं इफ यू आर प्रिपेयरिंग फॉर दिस एग्जाम। डिफिकल्टी लेवल टोटल सेम है। कमिंग बैक, अगर तुम सीरीज देखोगे 2, 3, 4, 5, तो आगे क्या होना चाहिए 6, लेकिन 6 तो सब में दिया, उससे कुछ फायदा नहीं हुआ। उसके बाद लास्ट में देखें अगर हम, तो 4, 5, 6, 7, लास्ट में 8, वो भी सब में दिया हुआ, सिर्फ हमें बीच वाला देखना है। बीच वाला क्या है, LORU, LORU, तो सारे अल्फाबेट्स दो दो से दे आर इंक्रीजिंग, सो नेक्स्ट विल बी X and therefore correct answer will be A, 6X 8। आगे बढ़ते हैं। In a series of first 24 natural numbers, each of 4 consecutive numbers are written इन द रिवर्स ऑर्डर, मतलब लेकिन 4 के पेयर। सो हमने पहले 4 लिया, 1 2 3 4, लेकिन उसको हमने उल्टा करके लिख दिया, 4 3 2 1। उसके बाद 5 6 7 8, सो 8 7 6 5। फिर 9 10 11 12, सो 12 11 10 9। फिर उसके बाद 13 14 15 16, 16 15 14 13। फिर 17 18 19 20, 17 सॉरी 20 19 18 और 17। फिर उसके बाद 23 22 और 21, 24 23 22 और 21। ठीक है, पूछा क्या, पूछा हमसे है द फॉलोइंग विल बी 8th नंबर टू लेफ्ट टू द 10th नंबर फ्रॉम योर राइट। सो यहां से 10वां कौन सा है, 1 2 3 4 5 6 7 8 9 10, सो ये हो गया हमारा 10th नंबर। इससे 8 number to the left of this number. 1 2 3 4 5 6 7 8. So 8th number हो गया इससे ये वाला. करेक्ट आंसर इज सी. ठीक है, आगे बढ़ते हैं. If P cross Q means P is brother of Q, P slash Q is P son of Q, P minus Q is P sister of Q. So काफी वेल नोन सवाल है रिलेशनशिप का. और स्ट्रेट अवे आपको इस वालों करने के लिए एक एक ऑप्शन चेक करना होता है. सो यू कैन डू इट गाइज. करेक्ट आंसर इज ए. आगे बढ़ते हैं. इन अ फैमिली ईच बॉय हैज एज मेनी सिस्टर एज ब्रदर्स. ठीक है. सो अगर मैं इफ आई एम अ बॉय, सो आई एम अ मेल, मैंने पॉजिटिव में इसको लिख दिया, तो मेरे कितने ब्रदर हैं? जितने ब्रदर हैं मेरे उतने मेरी सिस्टर हैं. ठीक है. तो अगर मेरे ब्रदर एक्स हैं तो सिस्टर भी एक्स होगी. सो टोटल लोग कितने हो गए? एक्स प्लस एक्स और मैं खुद. सो टोटल फैमिली मेंबर कितने हो गए? 2x + 1. ठीक है. उसके बाद हमें क्या दिया है? ईच गर्ल हैज ट्वाइस एज मेनी ब्रदर एज सिस्टर्स. अगर कोई भी गर्ल है, ठीक है, उसकी कितनी सिस्टर होंगी? अगर सब लड़कियां एक्स हैं तो उसकी सिस्टर कितनी होंगी? x - 1, क्योंकि एक वो खुद होगी. सो नंबर ऑफ सिस्टर्स विल बी x - 1. ठीक है. और ब्रदर कितने होंगे उसके? x और एक ये वाला आदमी. सो ब्रदर होंगे x + 1. ठीक है. अब पूछा क्या है कि जितनी भी सिस्टर है उसके 2 टाइम्स हैं ब्रदर. सो इक्वेशन विल बी लाइक दिस. सो 2x - 2 is equal to x + 1. So x is equal to 3. So the value of x is 3. So 3 3 और एक ये. So how many children are there? 3 और 3 6 और एक 7. Done.